the main burden of discussions today, as you all know, is the new criminal laws. We have a number of experts on the subject here, and during the planned programs of the panel discussions, there may not be sufficient time for our panelists, esteemed panelists, to do full justice. So I will request a couple of them to speak about the new criminal laws during this intervening time, which will be useful for everyone present here. I would first request Dr. KP Singh, former DGP of Haryana, to say a few words to begin with. Thank you, KP.
Thank you, sir. Good morning, ladies and gentlemen. I'll give you the brief background of the enactment of these laws. As we all know, we were following the IPC, CRPC, and Independence Act, which were primarily designed and enacted by the British to meet the requirement of a nation which they were ruling. The laws which were there were for the state, and this is evident basically from a single fact that the first chapter in the IPC, which we read, is offenses against the state. It shows the priority of the government or priority of that ruling dispensation. What was in their mind when they were giving those laws to us? Whereas in a democratic state, people have aspirations, government have their policies. In a welfare state, so many other types of priorities are there for the lawmakers. Although something was done here and there, but a substantial change was required. And with this need, the government constituted a committee consisting of some law professors, retired high court judges, senior police officers, professors of law, and gave them the mandate that you read line by line all the provisions and come out with a draft recommendations and laws. The committee worked for 2 years, from 2020 to 2022, and submitted their report. The recommendations were again given to a smaller committee for further detailed consideration and discussions. The committee further discussed about them for about a year and suggested some change and came out with draft 3 legislations, which were introduced in the Parliament on 11th of August 2023. The same day, these bills were referred to the Parliamentary Committee of Ministry of Home Affairs for further discussions. So the committee of the Parliament further discussed and made their recommendations to the Chairman Rajya Sabha on 10th of November 2023. After considering those recommendations, those 3 bills which were introduced in the August 2023 were withdrawn from the Parliament. And based on these recommendations by the Parliamentary Committee and other things which have come into the domain of the enactment, fresh 3 draft bills were introduced in the Parliament on 11th of December 2023. On 20th of December and 21st of December, these 3 laws were passed by the respective houses. And the President gave its assent on 25th of November 2023. These laws were notified on 25th December 2025. They came into operation on 25th of December 2025. But they did not come into force, because there was a clause that these laws will come into force on the day to be notified by the central government at a subsequent date. What was the reason? The law came into operation of 25th of December 2023, but did not come into force immediately. Reason was a lot of requirements were there to implement these laws. Some infrastructure was to be created. Some training was to be imparted to the policemen, to the judiciary, to other stakeholders. So it takes time. Some rules were to be framed, some delegated legislation were to be in order. So this time gap was given. Ultimately, government notified the date as 1st of June 2024. And this July, sorry. And this law came into force on 1st of July 2024. But there was a saving clause in all these three laws, that these laws will come into operation prospectively, not retrospectively. As we all know, penal law can be only prospective, not retrospective. Otherwise, it will be hit by Article 20, subclause 3 of the Constitution of India. Procedural law can be prospective as well as retrospective. But in this case, they said that it will also be retrospective. Because procedural law, whether it will be retrospective or prospective, is determined by the rule of fairness. Rule of fairness means if by applying retrospectively the procedural law, you are hitting a person on wrong side, his rights are curtailed, then it cannot be retrospective, it has to be prospective. Therefore, it was declared in the saving clause in all these laws that these laws will come into operation prospectively and not retrospectively. And all pending proceedings before 1st of July 2024, whether it is appeal, investigation, revision, review, whatever, it will be decided as per the old law. And everything which happened after 1st of July 2024, it will be held, it will be done as per the new laws. All the three laws were tweaked and were changed, but let me give you gist that the IPC was basically driven by the judge-made law. There were several judgments from the Supreme Court on different issues. So many sections were declared unconstitutional and they were removed from the statute book. So it was to accommodate those laws which were made by the Supreme Court into the statute, into the rule book. Another aspect which was there in IPC was section 48, which criminalized offense if a person sitting outside India abet an offense in India and that offense is committed in India, that person can be prosecuted here, extra-jurisdictional territorial jurisdiction. And it is in the context of national security, let me tell you, those anti-social element and anti-national element which are sitting outside India, in Canada, in US, in UK, we can register an FIR here now. We can conduct their trial in absentia as per section 356 under the new provisions. They can be convicted after following the trial. They will be attached with the tag of conviction. And when they will go to the foreign countries for asylum, the tag of conviction will be attached there. We have a solid point that he is a convict of law. He has been tried by a court of law. He has been convicted. He cannot claim that he is politically persecuted. So he should not be given asylum. This is the biggest advantage for national security. Another aspect which are there in BNS, new law which replaced IPC, are basically those which are concerning the Supreme Court judgment and which have been incorporated there. People often criticize that you have changed the numbering. You have disturbed the arrangement or sequence of offenses. But that was desirable. That was not by any design, but that was required. And the reason was that we have changed the sequence of the offenses in the IPC to show where our commitment lies. Now, our first chapter in the IPC or in the BNS is crime against women and children. This shows that in a democratic country like India, the first priority which the government put is on crime against women and children. So if you shift a chapter from back position to front position, it was inevitable that the numbering will change. Certainly, there were several other drafting mistakes in the IPC. In one chapter, in one section, you will have definition. In another chapter, in another section, you will have punishment and so many other things. They all have been consolidated. And you all know that there were about 551 sections in the IPC. And now the new law, there are only 358 sections, reduced, consolidated. And policemen have already adopted it. The major challenge was that how policemen will imbibe these new sections. They have already imbibed it and they are using it for the last 2-3 days without any hitch, without any problem. About BNSS, I will again say, people are criticizing that it is pro-police. I will say it is not pro-police. It is anti-heinous offenders. The petty offenders, they will get all the benefits in terms of community service, in terms of no arrest in petty offenses, etc., etc. There are several positions, the panelist will tell you. But the only change which we find, or the gist which we find in the BNSS is that the hardened criminal law has been made tough for them, which was the requirement of the society at this stage, at this juncture. Another aspect which we normally forget, and we policemen, and even in the lawyers, there are certain other areas which we do not even turn the pages to read. For example, commutation of sentence. The executive government were having power even to convert death penalty into fine by way of commutation. Even life imprisonment person can be set free after asking him to pay a fine. So certain provisions were there which required certain tweaking, certain remodeling. About jail administration, it is a forgotten entity in our criminal justice system. New system has been devised whereby jail administration has been given a new role. In 4 or 5 sections, the jail superintendent has been made stakeholder, and they have been given certain directions, certain rights to present themselves in criminal justice system. There are several other issues. Disposal of case property. We all have seen the police malkhana, what happens to them. A new concept has been made that as soon as a case property is produced before a judge, he will videograph it, he will get it photographed, he will make an inventory made and place it on the record of the file, and that will be the primary evidence during the course of the trial. And mandate is there that after that, within 30 days, the court have to pass an order for disposal of that case property so that it is not wasted in the police malkhana. Mercy petitions. We all have seen what happens to mercy petitions. One mercy petition after another legal things after another legal things. A streamlined procedure has been embedded in the new CRPC about mercy petitions. How it will be held, how it will be done, what is the time limit, so that the advantage which the criminals are getting, that one mercy petition, one criminal or one convict will file. It takes 2, 3 or 4 or 5 years to decide. After that, another co-convict, he will file. It will take 3, 4, 5 years. After that, the third will file. It will take 10, 15 years. And there is a judicial bar that unless and until petition of a convict is pending, his co-convict cannot be prosecuted, cannot be executed, or cannot be hanged. It resulted into delay. And there was a judgment of the Supreme Court in 2014, Shatrughan Chauhan versus Union of India, in which the Supreme Court said, if there is delay in execution of the death penalty, it should be converted into life imprisonment. So the convicts, death row convicts, they were getting advantage of these provisions. Now a detailed procedure with time limits have been prescribed. Several other new changes have been incorporated. The panelists will discuss. In the Evidence Act, basically, electronic evidence have been embedded into the scheme. The definition of primary evidence, secondary evidence have been changed. The certification which is required to make an electronic evidence admissible in the court of law, it has been changed. But that is something problematic area in which even the expert, they are not having one opinion. A lot of churning is required so that we could give a correct system of certification, because there is a lot of scope for manipulating those evidences. We all know, and most of the things we don't even know what is happening. What happened in Lebanon and all others, we all know how it can be manipulated and how it can be changed. We have to take care of this. So these are basically those things which I thought I should give as introduction, because otherwise the panelists will discuss in detail what are those detailed provisions. Thank you very much, sir, for giving me the opportunity.